Good morning, Council.
Good morning.
This is the case of In re, Gray, and Rice. Let's begin with Council's appearances.
Christopher Wharton and Kyler O'Brien on behalf of petitioners Angie Rice and Sean Childers Gray.
Welcome, Council. Okay, you have 20 minutes. Let's begin.
Thank you. May it please the court, we're seeking to correct two outlying cases from the 2nd Judicial District. Sex changes in Utah have been expressly authorized by the legislature and are routinely recognized by the executive branch and the vast majority of district courts across the state. I have 3 points that I want to address today. First is that the district court had the statutory authority to grant a petition for sex change. The second is that even in the absence of statutory authority, the district court had common law and equitable powers to grant the petition. And third, that the legislature has provided, and every other court that has interpreted, every other court has implemented workable standards for reviewing and granting a petition for sex change.
Mr. Wharton, do you know how these sorts of proceedings are handled in other states in terms of whether they first go to an administrative agency before they go to a court?
Yes, in the vast majority of states, they go to a court first. The main outlier is New York City. They, under the New York City model, they go first to the agency, and if the and then that could be reviewable by the court.
And why is that?
That's because the statute for New York directs them to go to the agency first. The vast majority of statutes direct the petitioner to go to the court first.
Do you know what type of review is taking place at the agency level in New York?
At the agency level, they're mostly just looking for sufficiency of evidence and checking the box in cases where they've tried to go beyond that, or where the agency has requested additional information that's not explicitly set forth in the administrative rule. Then the courts have overturned those and said that the agency is not in a position where they can add.
And when these cases have been litigated under states, has the Department of Health or the Department of Vital Statistics been involved as a party?
In some cases, yes, but in many cases, no. It's the situation that you have present here, where the petitioner is just seeking review as an appeal of right.
Can I ask you about that? So in those states where the Department of Health is a party, is that by statute that they're required to be made a party?
I think it's, yeah, and I believe it's that because the statute directs them to go to the administrative agency first, then when they appeal and then they're challenging the agency at that point.
One of the reasons that I ask is that this case raises some really important questions of statutory interpretation.
Sure.
You've also raised a constitutional question, and we have no adversary briefing. And the normal functioning of a court is under Article 8 of our Constitution is the exercise of judicial power, and the normal paradigm of the exercise of judicial power is to resolve a controversy, and we have no controversy here. We have what the district judge determined, and then we have your arguments. And you've made your arguments, but we're being asked to decide some pretty fundamental questions without the benefit of the adversary process. And I guess my question is whether that isn't an indication that this is perhaps beyond the judicial power, and that this ought to be the sort of thing where a state agency is involved in the first instance, or as an adversary party.
So in this case, because it directs us to go to the court first, even if petitioners had gone to the agency wouldn't be able to do anything without the court order.
Yeah, I understand that. I mean, I guess in a way my question is whether that statute isn't unconstitutional in terms of asking our courts to exercise something other than judicial power.
So this court has held that a justiciable controversy is present whenever there can be an adjudication of concrete legal issues, not abstractions. So any proceeding where a person can initiate a right or an interest that's protected by law or equity, that presents the adequate controversy requirement, and that was in Baird versus State. There's also a number of types of cases that that courts decide regularly in Utah that don't have an adverse party. There's name changes, there's guardianships, there's unsolemnized marriages, investigative subpoenas, and a number of different XREL
Uncontested
cases.
adoptions,
Uncontested
probate
adoption.
matters if nobody objects, a long list of cases where
Correct. And in this instance, you have, if I can turn back to the statutory authority, you have Utah Code 26211, which the legislature is clearly authorizing courts to make that determination, and that is an appropriate designation, because even though there is not an opposing party in this case, or in these two cases, it doesn't mean that there couldn't be an opposing party in other cases. There just didn't happen to be here. The other issue that would present a problem, it would actually be more of a constitutional, I think it would present more constitutional problems to go the other way, and to have an agency that was essentially determining standards of equity and applying common law to an agency decision. And that those are really heavily implicated by name and gender changes.
Well, I think you sort of hit it on the head there, right? The question is, what sort of authority are we being asked to exercise in determining this? Is it judicial authority, or is it executive or legislative? And so you seem to suggest that this is unquestionably judicial authority that we're being asked to exercise.
Yes. So in the Taylor case, which was a District of Columbia case that interpreting a very similar statute to Utah's, they determined that where the legislature has clearly stated that the courts have the authority to do this right, that the reason the court's role at that point is to scrutinize the adequacy of the evidence, and then also potentially apply common law and equitable standards if applicable. And then, so you have that. Then you have Utah Code 4211, which codifies the common law test for a name change, and and 26211, which was adopted in 1958, which was quite some time after the codification of the common law test, that incorporates by reference name changes. So when reading those two statutes together, the intent of the legislature is clearly to hold the same, to apply the same test for both name and sex changes. So
I don't doubt that at all in terms of the language of the statute and the implications to be drawn from it. And I don't disagree with the point you made a couple of minutes ago that you can find examples of instances in which courts historically have exercised power outside of an adversary system, outside of the resolution of a case or controversy or a dispute. But it seems to me that you can't deny that the normal course of the exercise of judicial power is to resolve controversies. It's to decide a dispute between parties, a plaintiff and a defendant, a prosecution and the defense. And that's the general paradigm, and those other instances seem to me to be exceptions to the general rule. So why shouldn't we apply the general rule here? This is a brand new frontier. These are important problems that you're calling to our attention. But wouldn't a decision of this court in this brand new frontier be better if informed by input from an adversary party?
just as I would point to, again, what the court has said, this court has said before in terms of what is a justiciable controversy. And I do understand that there is a concern when there are potentially constitutional issues present that you don't have the benefit of having both sides. But in every case, we're in searching name and gender change cases throughout the entire country, we're aware of no other claim, much less any authority, that says that this is a separation of powers issue.
Our cases have said, in Carlton versus Brown a few years ago, we said the judicial power is generally understood to be the power to hear and determine controversies between adverse parties.
Generally, yes.
There's no reason why the legislature couldn't set this up. Well, let me frame this in terms of a question. Is there any reason that the legislature couldn't set this up in the following way? To require someone seeking an amendment to a birth certificate to change the sex designation on the birth certificate to go in the first instance to the Vital Records Department and to seek an amendment, and if the Vital Records Department says no, then you've got a case and a controversy that goes to a district court. Is there any reason why the legislature couldn't set it up that way?
I don't know whether the legislature could or could not set it up that way as a matter, as like as a constitutional question.
I guess I'm sort of asking more of a practical question from your standpoint as an advocate for your clients. Do you see any substantial barrier to proceeding in that fashion? Because I can see plenty of upsides.
Sure, but that's not what the legislature, that's not what this.
Yeah, again, I get that point. I'm trying to ask a different one.
And it hasn't, and I would just point out, it's not just Utah. I mean, that what the court's talking about is really the New York City model only. And that, so that
Well,
would,
if we were counsel writing on a blank slate,
sure.
if you were writing the legislation, what would be the relative downsides and upsides of addressing this initially administratively versus initially judicially?
The downsides of addressing it initially at the administrative level would be that there are significant equitable and common law issues that need to be considered, and an agency is not an appropriate entity to do that.
Can you explain what you mean by that? What are the equitable common law issues?
So in named and gender change cases, as we talked about in a lot of the cases that we cited, like Hellig, for example, the court, even where the court determines that there is a test set forth by statute, which we say which there has been in Utah, there are still certain common law considerations that the court might want to consider, because the essence of the right at common law, which Utah courts were using the common law authority for name changes at the time of statehood, the essence of that right is to be able to establish, declare, alter, or terminate legal status in order to prevent confusion by the public, and also to create records that more accurately reflect the reality of the situation. And so to have an administrative agency weighing the variable factors that can go into that consideration. So for example, a person seeking a name and gender change might come in and they've held themselves out in their target gender for a year, and then another case comes in where the party has held themselves out for 6 months. At that point, an agency, if there's no direction from the statute, wouldn't be able to resolve that.
But of course, I'm not talking about cutting courts out of the process, right? I'm
Right.
just talking about adding an initial step that would give our courts an opportunity for adversary briefing and input. So if those concerns become important, then you have judicial review of the agency decision. So what am I missing?
Well, again, just because we don't have an opposing party in these two cases doesn't mean that there couldn't be opposing parties in other cases, and the court would have the benefit of having that.
The problem is,
May I
this is sort of the case that's before us now, and in which we're being asked to decide some really important legal questions.
So can I interrupt for a minute?
Yes.
All right. We have, I think, established that there are any number of cases that through the years and the history of this state, they haven't had an adverse party and courts have been deciding this issue, right?
Yes, that's correct.
Right. So as we said, probate cases,
Yes,
name change cases, right? Adoption cases.
yes.
So why should this case be treated differently?
It shouldn't. This case is properly within the.
What we have historically pronounced to be a justiciable controversy in this state. In addition, the state constitution doesn't have a case in controversy requirement, does it?
No, it does not.
All right. So common law, so at common law, we allowed for name changes for status designation, right?
Yes, that's correct.
And at the time of statehood, announced a statute,
Correct.
right? So we've been doing this without, in status designations by the courts, without objection for 100-plus years.
Correct.
And no court in the United States that has addressed this issue has taken up this separation of powers invitation.
That's correct.
Is a name designation the same thing? Does it have the same implications for our society as a sex change
There are potentially
designation?
there are potentially different implications, but the common law right again is the same, which the essence of which is to declare, alter, terminate legal status. And I would also add to that that the courts across the country have used common law authority to adjudicate not only name changes, but common law marriages, and even have adjudicated race. In the case of State ex rel Francis versus the Louisiana State Board of Health, the court was asked to adjudicate whether a petitioner came forward and said that the race on their birth certificate, which I believe listed them as white, was incorrect, and that they wanted to be listed as Indian.
Do you know, Mr. Wharton,
Yes.
when the sex designation is placed on a birth certificate for
Yes.
a newborn child, what guides the determination of how that designation is made? Is there any law or regulation on that?
I believe that it's, the doctor is the one that makes the certification. The doctor determines what the sex of the child is, and I believe that what the doctor looks to is medical standards rather than what the law says.
Do you know where that comes from? Is there a regulation that the Department of Health has issued that guides the doctor or a midwife or something?
I don't know the answer to that question, but I'd be happy to provide supplemental briefing on that. What I do know is that it is ultimately the doctor who makes the determination, not even the parents.
I presume that that's on the basis of either chromosomal testing or genitalia?
Yes. But however, there are instances where, there are intersex children that are born.
Right.
And the doctor has to make a determination, and in those instances, either determination is potentially wrong.
But again, I presume it would be based on some combination of chromosomal testing, genetic testing, plus observing physical genitalia.
I believe so.
So if that's the way the sex designation gets made at the time the birth certificate is initially, the sex designation is initially placed on the birth certificate, why wouldn't the way to read a statute that makes reference to a sex change designation being made later on be based on the same sort of inquiry?
Well, because courts from as far back as 1977 have recognized that there are multiple ways to classify gender, and the state of Utah.
But
The
you
only.
slipped, you quickly slipped from sex to gender.
Oh, I'm sorry.
So gender and sex are not the same thing.
Correct.
I don't know that those cases are helpful. One of the arguments you make is that interpreting, that you've tied the bow on the package
Yes.
would lead to equal protection problems. Because gender reassignment surgery for one sex is vastly more expensive and problematic than for another.
Correct. And the other problem that we would have in Utah is that the legislature, gender and sex are different words, but in Utah, the legislature, the only time they have acted to define a gender is in 5721-2, which is the SB 296, in which the legislature adopted a definition of gender identity that was set forth in the Diagnostic and Statistical Manual. So by doing that, the legislature wisely recognized that there are other ways to determine gender, and if the court were to adopt a standard that was based on genitalia alone, that would actually create a conflict with what the legislature
But here again,
has said.
this statute doesn't use the term gender, certainly doesn't use the term gender identity. It uses the phrase sex change. It seems like the first step for us, if we were going to reach the merits and got past the justiciability questions I was asking about earlier, would be to ask, what does the phrase sex change make reference to?
And that's why-
And that language, I think, has been on the books since 1981. Is that your understanding?
The first iteration of the code was, well, the first iteration of the code was 1958.
The reference to sex change appeared in 1958?
The adoption of 26211.
Right, but the
So-
language, operative language here of sex change,
Yes.
didn't that appear in 1981?
I believe that's correct, yes.
And so wouldn't our cases have always said that the first question for us to ask is, what is the plain meaning of the language of statute?
Right.
I assume that's when the statute was adopted. Wouldn't the question to ask be, in 1981, when people talked about a sex change, what did they mean? Is that the right question to ask?
I think that when we've discussed that issue in our brief, that even when you look at different definitions of what a sex change is, those can vary, and they don't all necessarily say that it's regarding genitalia. So, and certainly the court wouldn't want, I think the court would want to look towards 5721-2, because this is something where the legislature has just recently, and this is the only direction from the legislature given to the courts on how to determine what gender is. In that statute, they say that sex and gender are to mean the same thing, and they say that gender is to be determined by these, or may be determined by a list of factors set forth in the DSM-5. So that
Does it say gender by reference to DSM-5 or gender identity?
It says gender, well, it depends on, in subsection 22, it says gender identity is defined as, but I'm not sure which subsection, but in the same statute, it says that sex and gender are,
22.
22, yeah, that sex and gender are the same. The problem with, as I was saying earlier, that if the court were to adopt a narrow standard, which I would also say that courts across the country that are looking just at the genitalia, oh, sorry, may I finish?
Yes, but as long as we're asking questions.
Okay, all right. If the court's looking just at genitalia, that actually creates more problems than it solves. Again, it goes back to the plain meaning and it goes back to the common law right, which is that the people are going to be presenting themselves. Their outward appearance is going to be what their target gender is. And that is what's going to matter, because that's what we want the vital records to reflect. That's what addresses the public safety interest. That's what addresses the person's personal interest in being able to have congruity between their documents and between their appearance.
How about some middle ground? What about a test? I think it's similar to the Maryland test that suggests you've taken significant, irreversible steps towards medical steps, towards conversion, and you also regard yourself and hold yourself as subjectively your target gender.
That's actually the workable standard that every court in this state has adopted routinely granted and for last.
I don't have a copy of it, but I'm aware that when I was downstairs, Judge Stone issued a pretty thoughtful decision that I think articulated the standard in the first instance. Is that where it comes from?
I think that is part of it. I think that also it comes from the common law. When you ask a person to produce a letter from a doctor that says that they have transitioned, and as a matter of medical fact that this person is female or is male, that's compelling evidence for the court, because it speaks to the permanency that the person intends to permanently live in this gender, and it speaks to the good faith prong of the common law test, that the person's not seeking this for some fraudulent or improper purpose.
So are you suggesting then you would be happy with the test that relies on medical evidence, what a medical professional designates somebody's sex to be, as well as a subjective element of how they hold themselves out?
Yes, and I'm saying that the test that courts from 2nd District to 5th District to 8th District have adopted, that test allows for that. The current test that courts are using is the right test.
So sex change then would be effectively a term of art as the medical community reflects sex change.
Yes.
Do we know where the district court got that test from? So the district courts that are applying it, is that at the suggestion of counsel, or are they looking to cases around the country? Where are they pulling that?
I think it depends on, I think they're looking at the statute first and foremost, and seeing that because the 26211 incorporates name change both in the title and in the substance of the statute, that the legislature intended to tie the same standard, which is the common law standard.
I could be wrong, but my recollection was it was based on the Maryland Court of Appeals decision.
Yes. Sorry?
That test.
Yes, that test is the, well, what the problem in Maryland, though, is Maryland didn't have the statutory, they didn't have as much statutory clarity as we do in Utah. So even if so we're saying that the statute is sufficient, because the statute says that the test for name change and gender change are the same. But to the extent that there may be ambiguity, where there may be need for further clarity because the name change statute this court's jurisprudence around the name change statute are that it is a codification of the common law, that it would be appropriate for the court to look back to the common law if there were additional questions. And that's what courts have done. That's what they did in Maryland. In Indiana, the Court of Appeals found that even lacking statutory interpretation and lacking common law interpretation, that because courts and district courts are courts of general jurisdiction, similar to the way they are in Utah, that they have the equitable power to also grant the change.
Would that course be preferable to the Utah housing definition, gender identity?
I think I don't think we can ignore what the legislature did when they adopted that definition. I think that SB 296 was one of the most notorious, most scrutinized, most reported on, not only locally but nationally, cases in which the legislature adopted that definition. So I think that the courts should look to it. And
So did that statute retroactively go back and amend what was enacted in 1981 by the 1981 legislature?
No, I think it adds further clarity, because in 1981 the statute doesn't say we're talking sex change, and sex change means gender only.
But we have to ask what the 1981 legislature voted on, don't we? I mean, that legislation means whatever it means, and the fact that decades later a different legislature does something else in a different realm, I don't understand how that tells us what the 1981 legislation means.
I think that you look to the fact that that 26211 first adopted in 1958, that it's amended in the 1980s, that it was amended again in 1995, and that in each of the times that the legislature has looked at the statute, reopened the statute, they've determined that the word sex change is adequate.
Do you know, Mr. Wharton, how insurance underwriting handles sex changes? Because I think at least for some kinds of insurance, gender or sex matters. So
Yeah, it can be very complicated. But
beyond that, can you tell us, let's say, for example, that we were to accept your argument and that birth certificates in Utah could be amended in accordance with the standard you're recommending. Do you know how the insurance business would handle that?
I can tell you, as an advocate who's represented a number of these cases from across the state, having the congruity between a person's documents, their birth certificate, their driver license, has made it easier for the patient to obtain the insurance coverage that they need and the appropriate insurance coverage.
Of course.
What causes the problems is often the incongruity.
No, I get that from your client's standpoint. I'm just wondering from an insurance entity standpoint that's trying to make underwriting decisions, would they feel like hormone therapy of the relatively permanent sort that you're talking about is enough to change the underwriting considerations such that they would treat someone born a male but now considering herself a female for insurance purposes?
So in the vast majority of cases that I have worked on, in fact, all of the cases that I have worked on, they have accepted that definition, and that they've been able to either continue with their insurance or, I mean, there certainly have been issues on specific matters. I think that if you have a female to male transgender person, that if they have, I'm trying to remember, I believe it was that if they had a hysterectomy, that they were not, they looked more at what the surgeries and what the procedures had been to determine what would be covered in the future. So if they'd had a hysterectomy, they would no longer cover OBGYN care or something like that. And I'm trying to remember, please don't hold me to any of this, I'm trying to remember what the issue was in one particular case. The doctor's actually here, you probably ask her. What I found is that having the documentation helps insurance. It helps the patient.
You're talking about health insurance, I think, here?
Yes.
What about life insurance? Do you have any insights there?
I've not had any experience with, as far as I know, there have never been any problems with life insurance policies.
Do you know, or does the record reflect when the first district court approved such a change?
I don't know that.
Do you have a sense of when? I mean, was it a year ago, 2 years ago?
Here's, I'm gonna date myself, but here, when I started practicing law, in 2009, they had already happened.
That they had already happened?
They had already happened.
So whatever issues there might be with the insurance industry, they've had an opportunity to respond
yes.
legislatively and go and.
Yeah, oh,
if
yes,
there were
yes.
issues of these being granted by the district courts,
Yes.
there have been opportunities to take them to the legislature.
Yes, yeah, absolutely. So they were happening before 2009, and they've happened, I would say, exponentially more over the recent years. And as the court knows from our brief, that we've represented dozens of petitioners from all over the state of Utah, and the only issues that we've had with insurance have been based on the incongruity, not on between the document and the person. So, I mean, I understand that there's a downside to not having an opposing position because for purposes of informing the court. However, I think that it's also noteworthy that these petitions were unopposed, that the majority of petitions that I have handled have been unopposed because this is a policy that's working in Utah.
When they get opposed, who opposes them?
I've had 2 cases where they were opposed. The first was a female or male to female transgender parent who had minor children and was going through a divorce but had not obtained a divorce, and they did not provide notice to their spouse that they were changing the gender. And that presented a problem because they were still married and because there were minor children, and the district court at the custody trial was concerned by the lack of notice to the other parent because they believed that it implicated that parent's rights, both as a spouse and as and minor children. The other case that I'm aware of, and that was a second district court case that ultimately did grant the change. The other case was a case from Vernal, where my client was also male to female transgender individual and had a child, and the court wanted to know if the child had been given notice, but only if they were underage. If they were 18.
So the Department of Health or the Vital Records Department has not intervened and participated in any of these cases?
Not in any of the ones that I have represented.
So counsel, the state was given 25A notice
Yes,
and responded and declined to file an amicus brief
yes,
because, in their view, the appellants you do not challenge the constitutionality of relevant statutes.
correct.
So were we to decide this on separation of powers grounds, what would be our appropriate course in terms of the state's notice? Have they forfeited any opportunity, or should they have notice that the constitutionality of the statute is potentially at issue?
When the court asked the Attorney General's office in this case to weigh in, the court cited specifically that the reason was because there were potential constitutional issues. And even then, the Attorney General's office declined. So I don't know what other more appropriate notice could be given. I also know that, I mean, the executive branch is well aware of these. They routinely grant these changes to the birth certificate. So I think that, and they do it in cases where they know that where there had been concerns of the court, either constitutional or other, at the trial level, but once they got the order, that was sufficient to them and they were able to process the request.
To the best of your knowledge, has any executive branch declined to enforce a judicial order
No.
of a sex change?
No, and no.
I just want to make sure I'm clear on the standard that you're recommending. I think the questions have said that the standard that the district courts are using right now seems to be working.
Yes.
But can you specifically state what that is? Is it just a good cause standard?
I would say that essentially, good cause is sort of at the core of the standard. And it's been articulated in different ways, but it's essentially in every case in this state and in other states, it's, is there a good faith basis? Or is there any indication of fraud or impropriety? Has the person actually adopted this identity? So it's not a theoretical, like, I would like to become, change genders tomorrow.
By actually,
It's-
you mean both objectively and subjectively?
Yes. And that the person intends to live permanently in that identity, in that target gender. And so I think that those are the main issues that courts have considered, and I think that appropriately they've asked for more evidence. In some cases have required more evidence. In some cases we've required supplemental briefing. In some cases we've even had to call other witnesses. But by and large, courts are able to adjudicate these based on the testimony of the witness and the documents that we provide under declaratory documents, affidavits, or declarations.
In your brief, I think one of the ways that you phrased it was that the petitioner has to show that the requested change actually reflects their gender
Correct.
identity.
Yes.
And what you just said does seem to go along with that basic concept. Is that kind of the underpinning of this, or?
Yes, I would say it's, yeah, the underpinning is that same essence to the common law right to declare, alter, amend, terminate. And then the main concerns that the court has at that point are, is society being protected? Is this going to cause any potential law enforcement issues? And is this going to provide more security for the person? So all of those are considerations that sort of emanate from that rule. Unless the court has any other questions. In sum, I just ask that this court give meaning and effect to the legislature's intent in the statutes, that the court dignify the need for congruity between vital records and the person's actual reality, and also we would ask the court to reverse and remand with instructions to grant the petitions as prayed.
Thank you, counsel. You've done an excellent job in presenting these very important issues.
Thank you, and if the court has any supplemental briefing that you'd like me to do on the insurance issue or other, I'd be happy to do it.
Appreciate that.
Thank you.
And we'll now take this matter under advisement. Court is now adjourned.